Okay, thank you. Thank you very much, Nkumileo. Thank you. Okay. So let us proceed on. Let us go straight into our lecture for today. Like I said, my sincerest apologies for beginning our lecture late today. I mentioned that there was that problem basically, or not was, in fact, there still is that problem with electricity here, which has also affected our internet. So let us carry on from where we ended the last lecture we had. So we have been looking at the, the Judicial Code of Conduct. And we have been saying that when judges are judging others, who basically is judging the judges? We say that judges are not infallible. You know, these are human beings like any other, and they are prone to mistake. They can make mistake like any other person, basically. So when judges make a mistake in terms of their judicial functions, how are they basically to be held accountable? So we've been looking at the provision 43 of the Republican Constitution of 2016, and also the Judicial Code of Conduct Act of the laws of Zambia. So we looked at sections 3, 4, 5, 6, and 7 of the Judicial Code of Conduct Act. Those are the sections that we looked at, and we learned that there are basically three things about judges in their adjudicative responsibilities or functions. One, that judges are supposed to uphold the integrity of the bench. The bench is such a sacred place, and therefore, as people of the bench, we learned that judges, are supposed to uphold the sacredness, the sanctity, the integrity of a bench is supposed to be upheld by the judges. Secondly, we learned that the bench, the judiciary, is supposed to be an independent institution. Now, when we speak about independence of a judiciary, we are especially talking about independence of an institution and also individual independence. So independence of an institution is guaranteed in the Constitution. The provisions in the Constitution, we look at Article number 120 of the Constitution, in fact, starting from 118, when you look at Articles 118 all the way to Article number 120, you will see there provisions about the independence of a judiciary as an institution. However, there is also what is known as individual independence of a judge. Individual independence of a judge is where a judge is required now to act independently in adjudication of whatever matters that they may have an opportunity to adjudicate over. So there is that need for judicial independence at individual level. And there is also what is known as impartiality as a third strand of judicial code of conduct. There's what is known as impartiality. Now, a judge, as we learned about in the first semester of the first year, we learned that a judge basically is supposed to be impartial. And this impartiality we saw being demonstrated or illustrated by Lady Justice. We saw Lady Justice's face, and we learned that Lady Justice's face is blindfolded. Now, the reason for the blindfolding of Lady Justice's face is simply to ensure that when a matter appears before a judge, they are not really looking at individuals appearing before them. They are looking at the matters that are before them and the facts before them and the evidence before them, and they hear the witnesses that have been brought before the court to go and testify in the matters before them. So a judge is supposed to be impartial in their adjudicative function. So when a judge, ceases to be impartial, then the confidence of the public in the judicial system and in the court justice system erodes. The confidence of the citizenry in the justice system of the country is eroded. And once the confidence in the justice system by the general populace becomes eroded, the population of whatever country, doesn't matter where, will then start taking the law or matters into their own hands. And of course, there is nothing worse or bad about people having to take matters or the law into their own hands. The reason why most of the time that would happen is simply because the population will have lost confidence in the justice system. The population will have basically lost confidence in the justice system of a country. And therefore, to make sure that confidence is maintained through and through, the manner in which judges ought to conduct themselves as individuals that are supposed to instill confidence in the population, the manner judges conduct themselves on the bench especially becomes of paramount importance. Hence, the need for there to be some form of guide or code to guide the manner in which these judges basically conduct themselves. Hence, the provisions in the Constitution and also provisions in the Judicial Code of Conduct Act. So we looked at those sections. We looked at those sections of the Act. Now we looked at those sections of the Judicial that are especially of relevance to us for purposes of the discussion that we are basically having. We saw sections that are relevant to us. So let me just get to the page in our book that I'm sharing on the screen there, so that we basically now look at, we look at how judges are supposed to basically conduct themselves with regard especially to the aspect of impartiality, how that a judge ought to be impartial, and if there is any chance that the impartiality of a judge may be compromised, how that a judge basically is required to indicate to the parties before him and also then recuse him or herself. A judge is supposed to recuse him or herself where it becomes apparent that perhaps the manner in which a judge may conduct himself on the bench may be or may bring about a conflict of interest. So the aspect especially of impartiality is reflected in this Latin maxim or Latin term, nemo judex in causa sua, which I'm sharing on the screen there, and is basically highlighting the rule against bias. A judge ought not to be biased in the adjudication of matters before them. So I had given, to my recollection, I had given two cases that we were to sum up this topic with. I had given two cases that we were basically to sum up this topic with. One is an English case of 1852, And then the other is a Nigerian case of 2013, reported in 2013. So I say that we need to go through these cases. We look at what briefly the facts were in these cases, what decision was made by their lordships in these cases, and what the rationale was basically behind the decision that was made by their lordships in these cases. So let's begin by looking at the case of Grand Junction Canal versus Gimes. Let's look at the case of Grand Junction Canal versus Gimes, or Gimes versus Grand Junction Canal. From the readings that we did in our research, members, what did we come up with in the case of Gimes versus Grand Junction Canal? Anyone, members, to guide us or to lead us in that respect? What was the case of Gimes versus Grand Junction Canal about? Anyone? Nonkomerelo. Members, who is going to take the lead in guiding us in this matter? The case of Gimes versus Grand Junction Canal, a case that we had indicated last week that we go and research on, that when we come back today, we shall basically be looking at the case. What was it the case about? What were the brief facts in the case? What was the decision made on the facts? And what was the rationale? Yes, Hazel, please come in, Hazel.
Morning.
Morning, Hazel, and how are you?
I'm good, thanks. How are you, sir?
Very good, Hazel. Thank you very much. Yes, Hazel, you can lead us.
So the case of Dimes versus Grand Junction Canal was basically about judicial impartiality, specifically regarding conflict of interest in legal proceedings. It revolved around the issue of bias and the principle that justice must not only be done, but must be seen to be done. Yes.
Okay. Where did the conflict of interest arise from in that case, and who had an interest that was in conflict?
Okay. So from the facts of the case, the facts of the case as follows. Grand Junction Canal was a company which sought to build a canal, and it needed to obtain land for the project. So they pursued a land dispute regarding this canal project, which eventually reached the Lord Chancellor of England, Lord Cottenham. I think that's how you pronounce it. So he had basically ruled in favor of the Grand Junction Canal Company, but it later emerged that he had a financial interest in this company as he owned shares in that company. So this raised concerns over a conflict of interest because the judge stood to potentially benefit from the ruling in favor of the company.
Very good. Very, very good, Hazel, on that summary of what really transpired. So we have heard, members, what Hazel has just narrated to us in terms of what briefly the facts were in the case of Dimes versus Grand Junction Canal. And based on that, based on what Hazel has just narrated, his lordship, Lord Justice Cottenham, who then was the Chief Justice, the matter appeared before a bench where he sat, and the decision was made in favor of Grand Junction Canal. The decision was made in favor of Grand Junction Canal. It later, as Hazel has said, it later emerged that His Lordship, Mr. Justice Lord Cottenham, in fact, was a shareholder in Grand Junction Canal. He was, in fact, a shareholder in Grand Junction Canal. So when Dimes got wind of that information, when he learned about that information, he appealed the decision of the court that made the decision in favor of Grand Junction Canal. And the matter on appeal was allowed. The matter on appeal was allowed. Now, this is one very, very interesting point that I want us to basically look at. In their ruling, allowing the appeal, what did their lordships say? Allowing the appeal. So the appeal made by Dimes against the decision in favor of Grand Junction Canal. In their ruling, allowing the appeal, what did their lordships say on appeal? Members, is anyone able to share with us what was the sentiment of their lordships in allowing the appeal in this matter? Anyone of us members to guide us on that? Yes, members, is anyone able to guide us on that? When the appeal was allowed, in that case where Dimes appealed, the decision of a court which arrived at a decision in favor of Grand Junction Canal. It emerged later that the Lord Chief Justice, who was part of the adjudicators at the Court of First Instance, and on appeal, before the matter went to the final Court of Appeal, the decision basically was made for Grand Junction Canal. Later, it emerged that His Lordship, the Lord Chief Justice, was actually a shareholder in Grand Junction Canal. Dimes appealed, and the appeal was allowed. What was the basis? What did their lordship say on appeal? Members, what did their lordship say on appeal in that case? Anyone has any idea to let us know? Hello, members. Anyone? Josiah, Nicolette, Nompumelelo, Christine, Angel, Hazel. Anyone of us can come in. Yes, Angel.
I think it was held that the Lord Chancellor was disqualified from sitting as judge into the case because he had an interest in the action. So that is the reason why he was disqualified. So the verdict was influenced because of his interest to the company.
Okay, so Angel says the verdict was influenced because of the interest that His Lordship, Mr. Chief Justice Lord Cottenham, had in the company. Was that a fact that had been established by the court members, that indeed because of His Lordship's interest in the company, His Lordship basically had influence, that the decision was influenced by that connection that His Lordship had? Yes, Josiah.
Thank you, Counsel. The verdict stated that although there was no suggestion that the Lord Chancellor had in fact been influenced by his interest in the company, no case should be decided by a judge with a financial interest in the outcome. That is my submission, Counsel.
Indeed, indeed. Thank you very much. So, Angel, there was no evidence. In fact, there was no evidence whatsoever that the interest His Lordship, Mr. Justice Lord Cottenham, had in the company by, in any way rather, influenced the decision that was made by the court. There was no evidence to suggest that. However, standing by the principles of the rules of natural justice, nemo judex in causa sua, and the need for impartiality, in a matter. And remember also, when we looked at section 6 and 7 of the Judicial Code of Conduct Act, we learned that in section 6, it says, notwithstanding section 7, and then section 7 tells us about how that a judge should basically make declare interest to the parties in the matter, or to the representatives of the parties in the matter, about what might possibly be thought of somehow influencing or affecting the impartiality, meaning if there is any connection that the judge might have to any one of the parties, how basically that a judge should bring that to the attention of the parties, and that the parties then would deliberate on that. And if they say that it is fine, the judge should proceed on to hear the matter, how that a judge then would be allowed to proceed. But we saw how section 6 says, notwithstanding section 7. So even where, that is what we are being taught here, even where, you know, the parties or a judge may declare interest, and the parties say, we think there will be no issue of biasness, even though the judge somehow, you know, may have that connection. We think that the judge may not be swayed by that connection, and therefore the parties agree that therefore the judge must be allowed to adjudicate over the matter. What we are being told here is that even though that be the case, however, that shall not make it okay for a judge to sit and adjudicate over a matter. So based on that, we are being told that even where a judge might have declared that interest, and the party that loses a matter, especially the party on the opposite side of the party where the judge may be connected with or to, they can still appeal. That party can still appeal. And when they appeal, it is not going to be entertained by the courts that the judge, no, but your lordships, this appeal should be dismissed because the judge did declare his interest or her interest. And the counsel here said it was okay for the judge to proceed and hear the matter as a judge. That would not basically stand. What would stand basically is that a judge must recuse him or herself where there is a potential for a judge to be biased. So what the case of Gimes versus Grand Junction Canal is telling us is that even where there does not appear to be anything that the judge might have been influenced by the fact that he or she has an interest in one of the parties, and therefore may really have an interest in the outcome of the matter, it does not really matter that the judge was not somehow swayed by that particular fact of having that link or connection to one of the parties in the matter. Should the party that the judge did not have an interest in lose the matter, that party has the right to appeal, simply based on the fact that this judge, you know, had an interest, not on the fact that this judge's interest in the matter somehow influenced the manner in which he adjudicated over over this matter. So that is the thing, members. So the case of Dimes versus Grand Junction Canal is such an important case to us, a case that we should all basically be able, to learn and basically have information on our fingertips on. Okay, so that case is a classical case. It's an authoritative case on the aspect of nemo judex in causa sua. Anyone to share with us now, members, anyone to share with us now the case of Nestelo Gateway Group versus Al-Haji Abdul Aziz Abubakar Yari. This is a Nigerian case that transpired not very long ago. In fact, it only transpired about 11 years ago. Only about 11 years ago, meaning it's a new case. Anyone, members, to guide us on this case? Members, is anyone able to guide us on this case? Anyone? Members, is anyone able to guide us on this case? Hello, members. Are we going to have someone to guide us on this case? So Hazel guided us on the case of Dimes versus Grand Junction Canal. Now, let us look at the case of Nestelo Gateway Group versus Al-Haji Abdulaziz Abubakar Yari. Is anyone able to come in, members, and guide us on what transpired? What were the brief facts? As we had said, you should go and read. What were the brief facts in this case? What was the decision finally that their lordships made or said they could have, in fact, made? It could have made, yeah. Members, anyone? Members, is anyone able to come in? Members, anyone, please? No one is willing to guide us on this case, members? Josiah, would you like to guide us on this case?
Sir, I'm trying to find the case to no avail. My network is poor, sir.
Okay. Excuse me. All right. Nompumelelo, would you like to come in and guide us on this case? Hello, Nompumelelo, would you like to come in and guide us on this case? No, sir. Okay. Hazel, would you like to save us again, Hazel? Would you like to come in and save us again, Hazel, in this case?
Sir, this one I'm not that confident in because I had not found the entire thing. I just kept finding like newspaper articles. But
yeah,
from what I understood, it did involve a judicial misconduct issue. Nestelo Gateway Group had filed a lawsuit against I'll just say Abubakar because I can't pronounce the other name, who was a governor of the Zamfara state. Right. So, what were the facts of the case? The facts revolved around a contractual dispute between the Stello Gateway Group and Abubakar. They had a business dealing with the state, and it was represented by this governor. So the details suggested that the disputes involved payments or obligations related to a contract between the two parties, although I don't understand the exact nature of the contract. Yeah.
Okay. All right. So what transpired? Okay. Is anyone to assist Hazel members? Someone to assist Hazel. So Hazel has given us the brief facts. The brief facts. Is anyone able to add on to what Hazel has said in terms of the facts? Members, is anyone able to assist Hazel in this matter? All right, I'm going to ask someone to just read from here then. Let me just ask someone to read from here so that we can move on to the next topic. So someone should read just here. This is where the information actually is. So just read from there. Anyone can speak to us on those points that are there. Could someone just read for us, members, where we have highlighted there?
Sorry, is it my network or?
No, girl.
Okay, I feel better. Now,
He has gone off. How are you, Lilo?
I'm okay, Angel. How are you?
I'm good.
That's lovely.
Thanks.
That's lovely. I love this.
Sincere apologies. I had lost connectivity there. I was asking someone to read. Let me just bring back the document on the screen. I was asking someone to just read for us what I was presenting there. So let me bring it back on the screen so that someone can just read for us. Yeah, so I'm sharing again on the screen there. So anyone of us can just read for us what is being shared there. That is where the information about the case of Stello Gateway basically is. So I'm going to ask any one of us, just where I have highlighted there, if someone can read for us, please, that would be very, very good. Is anyone able to read for us, members? Anyone? Anyone? Yes, Nompumelelo, we can come in.
Okay. Similarly, in a Nigerian case, the chief judge of the Federal Capital Territory, Lawal Gumi, was found guilty of gross misconduct by breaching the Rule 1 clause 1 of the Nigerian Code of Conduct for Judicial Officers by the National Judicial Council, following allegations he interfered in a judgment given against his state governor by another judge in the matter of Nestelo Getaway Group versus Alhaji Abdul Aziz Abu Bakayari. Judge Gumi was alleged to have interfered with execution of the judgment delivered by a High Court judge of the Federal Capital Territory against the state governor, in which execution had already been levied in favor of the Nestelo Getaway Group. The council described the judge's conduct as most unethical and highly reprehensible, and that it would have recommended the judge sitting had he not voluntarily retired from office from the guilt of gross misconduct.
Okay, so that is what we have seen here. So there's a point that we take note of from what Nompumelelo has just read for us here, where they say that the council described the judge's conduct as most unethical and highly reprehensible, and that it would have, especially this part, that it would have recommended the judge's dismissal or sacking had he not voluntarily retired from office. So at the time that they were considering this matter against the judge, he had already voluntarily retired, probably knew that this is what was going to befall him. And to save face, of course, you just retire so that you don't get subjected to the embarrassment of being dismissed from the bench. So what we see here, members, is a classical example of how judges are expected to conduct themselves in execution of their adjudicative functions on the bench. So any person, therefore, who acts, one, in breach of what the Constitution has provided, and when I say what the Constitution has provided, I'm talking about what the Constitution has defined misconduct, gross misconduct to be. Remember, we looked at Article 266. We looked at Article 266 of the Constitution, and in there, among other things, it has defined what gross misconduct basically is. It has basically defined what gross misconduct actually is. So from that aspect, we are able to see, that the Constitution has first and foremost described what amounts to gross misconduct for purposes of a judge's behavior on the bench. Secondly, we see what the Judicial Code of Conduct Act has basically provided equally in terms of the conduct of a judge on the bench. Now, the Judicial Code of Conduct Act emphasizes especially the need for impartiality. Impartiality is what determines integrity of a bench. And individual independence of a judge also is what determines the integrity of a bench. So if a judge is failing, excuse me, is failing to act without impartiality, if a judge is being partial in his or her adjudicative function, basically that would mean that a judge is misconduct. conducting him or herself, and that itself is of his or her duties as a judge. Okay, so members, we have finished looking at the aspect of judicial code of conduct. These principles, as you have seen, we have looked at Nigeria, we have looked at the United Kingdom. We have also looked at the laws in Zambia. We also looked at the law in Zimbabwe. We looked at the constitution in Zimbabwe with regard to the independence or to the code of conduct for judges. I think we did that. So the principles are basically the same. The principles are basically the same. When a judge is appointed to that office, there is a certain level of expectation in terms of the conduct of a judge. If a judge is unable to live up to that expected standard of conduct, then of course that judge is sooner than later going to find himself on the chopping board, being sacked from the bench. In Zambia today, just today, news has filtered the public that the 3 judges who had been recommended for dismissal have since been dismissed. Of course, that case needs a lot of interrogation to have a proper understanding and to have an appreciation of whether indeed that case fell equally within the context of misconduct as has been defined in Article 266 of the Constitution and as has been described in the Judicial Code of Conduct Act. Why I say it needs to be interrogated is because it has some intonations, members. There is some connotation of political connectivity. There is some political connection. There is some political connection of sorts, really, that might make one think and believe that perhaps it is not so much about Article 266, maybe not so much about the Judicial Code of Conduct Act. But nonetheless, that is a process. We will have to interrogate that case quite well to see what indeed might have led to the 3 judges of the Constitutional Court in Zambia here being recommended for dismissal by the Judicial Service Judicial Code of Conduct, Judicial Complaints Commission, which recommended to the president that the 3 judges basically be dismissed. So today we have just read that the 3 judges have since been dismissed as judges of the Constitutional Court of the Republic of Zambia. Okay, so I'm going to invite 1 or 2 questions before we now start looking at another topic. Do we have any questions, members, that you would like us to clarify? Are there any comments that you would want us to equally, address at all? Members, do we have any questions that we have that you'd like us basically to look at? Okay, Angio Sankalimba, please come in.
Yes, I just want to find out the people or the people who sit at the Judicial Complaint Commission. Are they also appointed by the president, or what is the channel of their appointments?
Okay, that's a very, very good question, Angel. Majority of them are ex officio. Angel, majority of the members of the Judicial Complaints Commission are ex officio. Now, in their ex officio positions, the positions to which they are, which make them to be ex officio members of a Judicial Complaints Commission, to those offices they are mostly appointed by the president. To that office, they are mostly appointed by the president, and then from there, ex officio, they then become members of the Judicial Complaints Commission. So there is, to some extent, of course, one would say that there is a hand there is a hand in of the president or a sitting president in appointing those members of that body. And remember, because they are ex officio, what it means therefore is that when they lose the office that qualifies them to be members of the Judicial Complaints Commission or Judicial Complaints Commission, yes, moment they lose that office, it also means that they will have lost their membership of the Judicial Complaints Commission. So I know where Angel is coming from when he asks that question. He wants to see whether, you know, there is allegiance to the appointing authority, which is the president, which basically would mean that therefore there is no independence as well of a Judicial Complaints Commission as they seek to deliberate on these matters and all that, which would, of course, would be a very, very rational reasoning that one would have. And that, Angel, is one of the things that I always encourage students to always take note of, that as you approach the 4th year of your studies and you are about to start writing your directed research, what are some of the things that you would want to look at as you look at judicial independence? You know, is the judiciary really an independent institution in Zambia here? And remember that judicial independence, you know, cuts across the whole institution of a judiciary, which also includes the manner in which judges are removed. There was quite an exciting view or an excitement in Zambia when Article number 98 rather of a 1996 constitution was amended and replaced with now Article number 143, which now prescribes the manner in which judges ought to be removed. Before the current provision, the president would simply appoint a tribunal for purposes of removing a judge. That was, of course, seen directly to be the president having to have so much power over the institution of the judiciary, especially with regard to removal of judges. So when now the 2016 constitution made a provision to make amendments on how judges would be removed now through the Judicial Complaints Commission, it was thought that to some extent, you know, there is some semblance of judicial independence. But I think what those that may not be analytical enough omitted to see, and therefore one would say that their excitement perhaps shouldn't have been so much excitement. What we might have omitted to analyze is that though now there is a Judicial Complaints Commission, we also need to look at, we need to interrogate how the members of the Judicial Complaints Commission actually are appointed, or how do they actually qualify to be members of a Judicial Complaints Commission. Has the hand of the president completely been cut off from this process that leads to the removal of a judge from the bench? You know, if the hands of the president has not entirely been cut off, what it then therefore means is that still judicial independence is at risk. Still judicial independence is at risk. So my challenge then to you all members is to look at the provisions in the Constitution of the Republic of Zambia in terms of how the Judicial Complaints Commission is actually appointed, and to see what hand now the president has in the appointment of the members of a Judicial Complaints Commission. So I'll give you that task. We can discuss it briefly the next class we are going to have. But of course, today we are going to introduce a new topic. But before we proceed on next week to our new topic that we are going to be introducing today, I will want you to make a submission, each one of you. I will want you to make a submission on how the members of a Judicial Complaints Commission are appointed, and whether indeed, you know, the hands of a president or the hand of a president has completely been cut off. So that was the whole idea of making these amendments from the 1996 Constitution, which required the president having to appoint a tribunal, to now the Judicial Complaints Commission having to initiate investigations against a judge, with a view, of course, to having that judge removed from the bench. So we need to be very analytical and very critical. We need to be critically analytical in our thinking and our consideration of these matters. That is what will make us become better contributors to the societies in which we live, because the ordinary man in the street there will say, no, now the president is not the one that appoints the tribunal to remove a president, to remove a judge rather. And therefore, there is now judicial independence because the president doesn't have a hand. The president, I want you to go and look at whether the president does not have a hand. I'm not going to say what I wanted to say because then I'll be preempting. So I want you to go and look at whether, you know, the hand of the president has indeed, you know, been removed from the process of removing a judge, so that we say that the president will only now work on the recommendations of the Judicial Complaints Commission, and not so much the president himself having to have a hand in appointing a tribunal for purposes of removing a judge from the bench. Okay, members, any more questions? Angel, have we satisfactorily addressed the point that you raised, Angel? Very good, very good. Okay, members, any more questions? Nompumenelo, Hazel, Sipo, Catherine, or rather Christine? Do we have any more questions, members? No questions from Nompumenelo, no questions from Hazel. Sipo and Christine, do we have any questions at all? No questions from Christine. Okay, then Sipo, you can come in with your question. Tom, Sipo, do you have a question? Probably not. All right. So if there are no questions from the members, let's proceed on. And we now start looking at, a new topic altogether. This topic operates within the context. This topic operates within the context of judicial review. It's very, very similar to judicial review, but rather different in terms of procedure and commencement. Yeah, it's quite different from procedure and of course commencement, which commencement also might mean procedure. So let us look at the Office of Ombudsman. Let us look at the Office of Ombudsman. in Zambia here, formerly known as the Office of the Office of Commission for Investigations, which was led by the Investigator General, So, members, we have learned, or we have been learning, that administrative law is all about procedure. We have learned, or we have been learning, that administrative law is basically all about procedure. It is about ensuring that in the governance of the country, there is no arbitrariness, and there is also no discretion in the manner those that have been entrusted with the functions of running the affairs or running the administrative affairs of a country are actually conducting themselves or running the affairs of a state. We say that that is what the rule of law is about. That the rule of law is about ensuring that those that have been entrusted with the administrative functions of running the affairs of the state are actually doing that within the parameters, within the confines of the law. We learned that, however, where they act contrary to what the law provides, which then would be referred to as ultra-virus conduct, they would be brought before the courts of law via an application that we refer to as judicial review. We spent quite some time, and by now I expect each one of you to be experts in judicial review, because I think we spent quite an extensive amount of time looking at what really judicial review is and what it is all about. However, besides judicial review as a mechanism for upholding the rule of law, besides judicial review, there is also another mechanism that was brought about. And this mechanism was brought about as a simplified version of initiating a complaint by individuals on how public institutions or individuals working in public institutions are actually making decisions, which decisions may have a negative impact on the institution or on the individuals, in fact, working in those institutions. So, judicial review was seen to somehow be very prohibitive to so many people because of the procedural requirements that one has to basically go through for them to be able to have their matter heard by a judge in the courts of law. So you would find that under judicial review, even where one would really have a good reason for applying for judicial review, they would be hesitant to do so, not because of anything, but one, because of the procedural requirements. Number two, because of the legal requirements. They need to have a representative, a legal representative who understands, the process of judicial review, and who not only understands the process of judicial, but a legal representative who, in fact, is well versed, who is confident in matters pertaining to judicial review. So you would then find that a lot of people would shun, a lot of people, even when they would have a good case, they would shun from bringing a complaint before the courts of law by way of judicial review. What that basically meant was it brought about a lot of resentment and frustration by people, especially those working in public institutions, these institutions where those decisions were being made are not being made properly. And therefore, the institutions themselves were being affected, and the individuals working in those institutions equally were being basically affected. So they decided sometime so many years back, you know, jurists of the 1700s, 1600s, jurists of that period decided that there was perhaps a need now to come up, with a much more user-friendly process of seeking redress or grievance redress, redressing grievances that individuals basically might have in terms of the manner decisions or indecision was basically arising in places of work, in especially public institutions. And therefore, the aspect of ombudsman was born as a simplified mechanism to redress public discord in public institutions. So let's just read the introduction that is there. It says, public protector, functions, powers, and procedures. Introduction. It says, administrative justice requires that as much and as simply, that was especially the principle behind the office of ombudsman or the office of public protector, or as the case is in the United Kingdom, the office of parliamentary commissions for investigations. Administrative justice requires that as much and as simply as possible, the citizens have recourse to control mechanisms where there is ultra-virus conduct on the part of statutory bodies, or where mala fide or maladministration exists in statutory bodies. Different measures exist for ensuring that statutory bodies operate intra-virus, and mala fide or maladministration is checked in public administrative bodies. This chapter looks at one of the mechanisms that exists for ensuring mala fide or maladministration arising from persons in state institutions is checked. The chapter looks at the institution of public protector, the origins of the institution, its legal framework, functions, powers, and procedures through which the institution operates. So the institution of public protector is what, members, we are looking at. I want us to read here. I'm going to give you just this time, 2 minutes, to just read what I have highlighted here, which is basically the origins of this institution of public protector, which in countries it originates from, has been known from as far back as the 1800s, the early 1800s, as the office of ombudsman. And then we shall see how countries like Britain, when they equally decided to have this institution, before later that institution transferred to us here by virtue of this historical link of colonization that Zambia, Zimbabwe, Botswana, South Africa have with Britain, how that this institution equally found itself here. in Africa, Zambia, Zimbabwe, Botswana, South Africa in particular. However, this institution did not have its origins from the United Kingdom. This institution traces its origins back to the Scandinavian countries. The Scandinavian countries are countries in the east, the northern part of Europe, the furthest northern part of Europe. And these are countries that are least known about, perhaps because they didn't do so much exploits in terms of explorations and setting up empires as the French, the Germans, the Italians, the Britons, the Portuguese, and the Spaniards did. They perhaps kept to themselves. But these are countries that have very, 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 very good democratic credentials. Scandinavian countries that to them, as far back as 1809, they were already thinking of how do we make it simple for people to actually, seek redress, for people to complain without necessarily having to be restrained by the rigors of procedure that really are involved in bringing matters before the courts of law. So they thought, why don't we come up with that, with just an office where people can walk in? The same way they would have a matter redressed by the courts of law, their matters would be redressed by this office. Only thing is that the manner in which they will initiate the process will be extremely different from the manner the process would be initiated in the ordinary course of litigation or application for judicial review. So they came up with the Office of Ombudsman, and the first country to have come up with that office basically is Sweden in 1809. The Finnish established theirs in 1919. The Danes established theirs in 1955, and the Norwegians also established theirs in 1963. We shall see what the Britons did, leading then to the establishment of the same as well. Okay, members, so let us read there. When you finish reading here, kindly let me know so that I can then proceed on to explaining. Okay. So whoever finishes first, kindly should let me know. Whoever finishes first should let me know so that we can then proceed on, members.
We're done, sir.
Okay, thank you very much, Hazel there. Thank you very much. So let's now proceed on to looking at the Britons. the Britons. So in the United Kingdom, an inquiry was conducted in 1961, and the report of inquiry made the following findings. Which formed the basis of establishing the institution in that country. Now, I enjoy reading this passage. Because, you know, to others, it may be a small thing, but to others, it may be something that brings about frustration and resentment, but it actually affects their efficiency in the delivery of their functions as public servants, especially working in these public administrative institutions. So to make sure that, you know, there are no frustrations and resentments arising from the manner, you know, judicial review, for example, is to be brought, which would be somehow prohibitive or restrictive. A new mechanism or system is brought about. So a continuous flow. This is a committee, the Citizen and Administration, the Wyatt Report. The Wyatt Report was constituted in 1961 by the government to basically look at whether it was necessary for Britain also to have this institution of ombudsman. Our friends decided if we are going to establish this body, there has to be a good reason for us to do that. So we are going to appoint a committee known as the Wyatt Committee, led by Wyatt, of course. And this committee is then going to give us what their findings would be and their recommendations in terms of whether indeed it is necessary for this committee, or rather for this body, the ombudsman, to actually be established in the United Kingdom. So these were the findings of that committee. It says a continuous flow of relatively minor complaints, not sufficient in themselves, or to attract public interest, but nevertheless of great importance to the individuals concerned, which give rise to feelings of resentment and frustration of the inadequacy of the existing means of seeking redress, which give rise to feelings of frustration and resentment of the inadequacy of the existing means of seeking redress. The report established that the existing machinery was wanting, that parliamentary question time was inadequate to deal with the volume of problems arising, and that if a complaint was made directly to the government department, the department investigated the complaint. If a member of parliament attempted to investigate, he could not gain access to all departmental documentation, and consequent to that, the report advocated establishing a permanent office independent of, now listen to this, very, very, look at this, members. This is how it is supposed to be. And I'm glad that our friends in South Africa have adopted it in the manner our friends in Britain recommended it to be. In Zambia, unfortunately, it is part of the executive wing of the government. There are so many things we need to address, members. If we are going to talk about bringing good governance to ourselves as a country, there are quite a number of things that we need basically to address. So it says here, he could not gain access to all departmental documentation, and consequent to that, the report advocated establishing a permanent office independent of the executive and accountable only to Parliament, removable from office only after a successful address had been moved to both houses of Parliament. You see how powerful this institution basically is in countries like Britain in terms of an institution of checks and balances. You know, this is what it is, members. The Office of Ombudsman is also another mechanism for checks and balances, but a very simplified process where now you and I, not so much the judiciary, not so much the legislature over the executive, but you and I as individuals that feel aggrieved by the inaction or maladministration that is happening in these institutions of government. So if it is to effectively investigate, it becomes crucial, very, very important that this institution is made independent of the executive, the very institution especially that it is made to investigate, and secondly, that it is not made accountable to that institution, but to Parliament. But also, if it is to be made accountable to Parliament, we must make sure that it is a Parliament that is operating within the context of proper separation of powers, especially with regard to separation of personnel. So it says that the report advocated establishing a permanent office independent of executive and accountable only to Parliament, removable from office only after a successful address had been made to both houses of Parliament. Following the report, the institution was first adopted and referred to as the Parliamentary Commissioner for Administration in 1967, and has since expanded to include the Health Services or the Health Service Commissioners for England, Wales, and Scotland, the Local Government Commissioners for England, Wales, and Scotland, the Legal Services Commissioner. Addition to investigating complaints on administration of government, private sector ombudsmen have equally been established in the United Kingdom, such as the Banking Commissioner, Building Societies Commissioner, Corporate Estate Agents Commissioner, Pensions Commissioner, Personal Investment Authority Commissioner, Investment Commissioner, Insurance Commissioner, Insurer, or rather Commissioner for Trades Union Members, etc., etc. So, what was the purpose? This is here, you know, to ensure the tenets of good governance and promotion of democracy are entrenched in the system of governance. Other countries have adopted the institution of ombudsman in their constitutions and acts of parliament. The South African Constitution, for example, establishes the institution which is referred to as the public protector. where its functions and powers are conferred and an act of parliament provides operational framework. The South African Public Protector Act confers wide-ranging powers on the institution to investigate any conduct in state affairs or in public administration in any sphere of government that is improper or result in any impropriety or prejudice, and to take remedial action against any impropriety. So this is the background, members. This is the background to the institution of ombudsman. So in Zambia here, we shall now look at the Office of Ombudsman, Public Protector in Zambia. Like I mentioned earlier, first it was known as the Commissioner or Commission for Investigations, and it was headed by the Investigator General. Upon independence in 1964, we set up this organ or this body, and it was known as the Commission for Investigations, and it was headed by the Investigator General. In 2016, we changed the name. Back in Zambia, first it came in 1973. In 2016, we changed the name from that of Commission for Investigations and to be headed by the Investigator General. We changed the name to the Office of Public Protector, and it is headed by the Public Protector. It is headed by the Public Protector. So we shall look at the legal framework of how this organ works in Zambia here. We shall look at how effective it is in comparison to other countries' public protector or ombudsman's office. We shall look at some of the gaps in the law that perhaps makes this body not to be as effective in Zambia here as it is in other countries. And then from there, we shall see what then as a country we may need to do in terms of best practices to make sure that this body, is operating with the efficacy, that indeed it had been established for when it was established first in 1973 and then later in 2016 Constitution and 2016 Public Protector Act. So we shall end here for now. I will then allow you to go and read through the Office of Public Protector in Zambia, where in the Constitution, which articles of the Constitution it is established under, what is the purpose, what is the purpose and function, what is the purpose and function of this organ, what is the purpose and function of this organ of public protector. Then from there we shall end. Then I think that would mean the end of our administrative law class for the semester. After that, we shall then just be doing, maybe we shall do two revisions for the exams before then we call it end of semester lessons, and you guys then start preparing for your end of semester exams. So we end our lecture here now, but of course, if there are any questions, please feel free to ask those questions now. Any questions, members? Any comments? Any concerns? Josiah?
No comments, sir.
No comment from Josiah. Angel? Hazel? Christine? Okay. Now, Josiah, do we have this office in Zimbabwe? And if so, what is it called? Okay, Josiah has left. All right, members, so we come to the end of the lecture, and we shall see you on Monday again at the same time. Enjoy the rest of the day, and do have a lovely week. Thank you very much for your attention.